Navigating kidnapping charges in Okmulgee County. Kidnapping charges are among the most serious criminal allegations a person can face in Oklahoma. A conviction can expose an individual to lengthy prison sentences, permanent felony records, loss of civil rights, and severe damage to personal and professional reputation. Because of the seriousness of these cases, individuals facing kidnapping allegations in Okmulgee County should understand how Oklahoma law defines kidnapping, what prosecutors must prove, and why early legal representation is critical. How Oklahoma law defines kidnapping. Under Oklahoma law, kidnapping generally involves unlawfully taking, confining, restraining, or carrying away another person against their will. Prosecutors commonly allege that the accused used force, threats, intimidation, or deception to interfere with another person's liberty or movement. Kidnapping charges can arise in a wide variety of factual situations. Some cases involve allegations of abduction by strangers, while others stem from domestic disputes, custody disagreements, altercations between family members, or incidents connected to other alleged crimes. The exact circumstances of the alleged restraint or movement often become central issues in the case. Kidnapping allegations frequently accompany other charges. In many Okmulgee County prosecutions, kidnapping charges are filed alongside other criminal allegations. Prosecutors may combine kidnapping accusations with claims involving domestic violence, assault and battery, robbery, sexual offenses, child custody interference, or weapons charges. In some situations, prosecutors use kidnapping allegations to substantially increase the seriousness of the case and potential sentencing exposure. Even a relatively brief restraint or movement of another person may become the basis for a kidnapping charge, depending on how law enforcement interprets the facts. Because of this, careful analysis of the evidence and surrounding circumstances becomes extremely important. Intent and consent often become major issues. Many kidnapping cases our criminal defense attorneys in Okmulgee County handle involve disputes regarding consent, intent, or what actually occurred during the incident. For example, prosecutors may claim a person restrained another individual against their will, while the defense may argue that the interaction was voluntary, misunderstood, exaggerated, or taken out of context. In domestic or family-related situations, allegations may arise during emotionally charged disputes where witness accounts conflict significantly. The prosecution generally carries the burden of proving beyond a reasonable doubt that the accused unlawfully restrained or carried away another person without lawful authority or consent. Evidence used in kidnapping cases. Kidnapping prosecutions often rely heavily on witness testimony and circumstantial evidence. Investigators may attempt to build the case using statements from the alleged victim, eyewitness accounts, surveillance footage, electronic communications, GPS data, social media evidence, or law enforcement observations. In some cases, prosecutors may also introduce photographs, medical records, recorded interviews, or forensic evidence. Defense attorneys frequently examine inconsistencies in witness statements, timelines, credibility issues, and whether the alleged facts actually satisfy the legal elements required for kidnapping under Oklahoma law. Because these cases often involve emotional accusations and conflicting accounts, the details of the evidence become critically important. Kidnapping charges involving children. Kidnapping allegations involving children are treated especially seriously in Oklahoma. These cases sometimes arise during contentious custody disputes, disagreements between parents, or allegations involving interference with court-ordered custody arrangements. However, not every custody-related disagreement automatically constitutes kidnapping. The surrounding facts, court orders, parental rights, and the accused's intent may all become important legal issues. Cases involving children frequently involve simultaneous proceedings in family court in addition to criminal prosecution. Potential penalties for kidnapping in Oklahoma. Kidnapping is generally prosecuted as a felony offense in Oklahoma. A conviction may result in substantial prison exposure, probation restrictions, fines, mandatory supervision conditions, and long-term collateral consequences. Beyond incarceration, a felony conviction may affect employment opportunities, firearm rights, housing applications, professional licenses, and reputation within the community. In some situations, related allegations may also affect child custody rights and family court proceedings. The potential penalties often become even more serious when prosecutors allege weapons were involved, injuries occurred, or the allegations involve children. Defending against kidnapping allegations. Every kidnapping case depends heavily on its unique facts. Possible defenses may involve lack of intent, consent, mistaken identity, false accusations, insufficient evidence, or challenges to whether the alleged conduct legally qualifies as kidnapping. Some cases involve disputes regarding whether the alleged victim voluntarily accompanied the accused or whether the restraint was incidental to another event rather than a separate criminal act. In other situations, defense attorneys may challenge the reliability of witness testimony or the accuracy of law enforcement conclusions. Because prosecutors often aggressively pursue kidnapping cases, early investigation and preservation of evidence can be extremely important. Why early legal representation matters. Many individuals accused of kidnapping make the mistake of attempting to explain the situation to investigators before consulting an attorney. Statements made during interviews may later be misunderstood, mischaracterized, or used against the accused in court. We understand how serious felony allegations can be for both the accused and their family. For a free and confidential consultation with one of our attorneys, call us at 918-621-8083.